Hello, my name is Marielle Jingco, and my section of this group project is What are sex offender statuses? And you can find this on pages 642 to 646 of the textbook. So what are sex offender statuses? Well, in 1937, Michigan passed the first sexual psychopath law, which led to several states to place sex offenders in a special legal category. These states believe that some of those who are repeatedly found guilty of sex crimes have a mental disorder, so they categorize them as mentally disordered sex offenders. People who are classified are convicted with a criminal defense, and this is why legislators believe they are judged responsible for their actions. But instead of being sent to prison, they are instead sent to a mental institution to receive mental treatment. This is because legislators believe that these sex offenders are psychologically disturbed. Over the past 2 decades, most states have been abolishing the mentally disordered sex offender laws for several reasons, one of which is because it's difficult to apply. Some states require that the offender be found sexually dangerous beyond a reasonable doubt. The problem with that is that it is often a judgment that is difficult for even clinicians to make. Another reason is that some states may require that the person must be a good candidate for treatment. This is also still a judgment that is difficult for clinicians to make. Racial bias is another reason as to why a lot of states want to abolish these laws or have abolished these laws already. And this is because it often affects the use of the classification. White Americans are more or twice more likely to be offered this alternative than African Americans or Hispanic Americans who have been convicted of similar crimes. And this isn't fair because this is seen as an attractive alternative to imprisonment. Last but not least, state legislators and courts are now less concerned about the rights and needs of sex offenders than they were before. And this is because of the increase of sex crimes taking place across the country, particularly in cases where children are the victim, and this causes outrage. So in response to the public outrage, the increased number of sex crimes, 21 states and the federal government have instead passed sexually violent predator laws or sexually dangerous persons laws. The laws call for certain sex offenders who have been convicted of sex crimes and have served their sentence in prison to be removed from prison before their release and committed involuntarily to a mental hospital for treatment if a court judges them likely to engage in further predatory acts of sexual violence as a result of mental abnormality or personality disorder. So this differs than the mentally disordered sex offender laws because instead of sending them to prison, rather, one second, instead of sending them, sorry, brain fart. This differs from this mentally disordered sex offender laws because instead of sending them to mental facilities rather than imprisonment, they send them to prison first, and then before their release, they are sent to a mental facility involuntarily to get help if the court judges them to most likely commit these crimes or similar crimes again, and then they release them into society. But This is faulty because although required in sexually violent sex offender cases, the laws don't provide much guidance as to how to make the judgment of whether the soon-to-be released prisoner would commit these crimes again. Because how do you create, or how do you make that judgment? Criminal commitment and incompetence. Defendants may be judged to be mentally incompetent to stand trial regardless of their state of mind at the time of the crime. This requirement is meant to ensure that defendants understand the charges they are faced with and can work with their lawyers to prepare and conduct an adequate defense. Mental incompetence is a state of mental instability that leaves defendants unable to understand the legal charges and proceedings they are facing and unable to prepare an adequate defense with their attorney. The issue of competence is mostly raised by the defendant's attorney, although prosecutors, police officers, and even the judge may raise it as well. The judge orders a psychological evaluation, usually on an inpatient basis when the competence is raised. If the court decides that the defendant is incompetent, they are typically assigned to a mental health facility until competent to stand trial. There are many cases of criminal commitment that result from decisions of mental incompetence than from verdicts of not guilty by reason of insanity. However, the majority of the criminals that are institutionalized for psychological treatment in the US are instead people who are already convicted, who have psychological problems that have led prison officials to decide that they need psychological treatment. As you can see on the table right here, which was conducted in several Western countries, psychological disorders are much more prevalent in prison populations. There are also cases where an innocent defendant is deemed incompetent to stand trial. And they could spend many years in a mental institution with no opportunity to there are also cases where an innocent defendant is deemed incompetent to stand trial, they could spend years in a mental institution with no opportunity to disprove the criminal accusations against them. Also, some defendants have served longer sentences in mental health facilities because they are waiting for a ruling of competence than they would have served in prison if they had already been convicted. This possibility was reduced by the Supreme Court when they ruled sorry, brain fart. This possibility was reduced when the Supreme Court ruled in the case of Jackson versus Indiana, 1972, that an incompetent defendant cannot be indefinitely committed. After a reasonable amount of time, he or she would either be found competent and tried, set free, or transferred to a mental health facility under civil commitment procedures. And this leads us to my last slide. Civil commitment is a legal process in which a person can be forced to undergo mental health treatment. Although many people who show signs of mental disturbance seek mental treatment, many people are not aware of their mental state and are opposed to treatment. This is when civil commitment can be put in place. The legal system, on behalf of the state, also has taken on the responsibility of protecting patients' rights during treatment. This protection is not only for patients who have been involuntarily committed, but also for those who seek treatment voluntarily, even on an outpatient basis. So our legal system permits involuntary commitment of individuals when they are deemed to be in treatment and dangerous to themselves or others. A person who is suicidal may do things like drive into traffic because they may act recklessly. And something like driving into traffic is both dangerous to the person driving into traffic, but it is also like extremely dangerous for the people they're driving into as well. So it doesn't only affect them. So the intention of involuntary commitment is to protect the interests of individual and of the society. Under, and I'm sorry if I get this pronunciation wrong, but under parens patriae, parent of the country, the state can take action to protect patients from self-harm by involuntarily hospitalizing them. According to this section, the state also uses police power in hopes that it would protect the society from individuals who may be dangerous to themselves or others. But as we could see with today's news, there are many cases that suggest that police cannot handle mental health crises. In these particular cases, the police result in harming or even killing the individual who needed mental help. Even though the individuals in these cases aren't aggressive or acting aggressively towards anyone. I personally felt the need to add this information in, but I will not be diving into it because I'm not sure if I'm allowed to speak on my opinion in this project. I just thought I would add that information there. And this concludes my part of the section. This is my last slide. So yeah, thank you. Oops.